Hello, everyone, and welcome to the third panel of the 2023 Originalism Symposium. And this one is on originalism and free exercise. Should the court overrule Smith? In Employment Division versus Smith, the Supreme Court famously held that the free exercise clause of the First Amendment does not guarantee religious exemptions from neutral laws of general applicability, no matter how severely they burden religious practice. While the opinion was written by professed originalist Antonin Scalia, many scholars have questioned whether Smith was correctly decided as an original matter. The Supreme Court has taken note. Concurring in Fulton versus Philadelphia, decided 2 summers ago, Justice Barrett confessed that she finds the historical record more silent than supportive, but that the textual and structural arguments against Smith are more compelling. Justice Alito was more frank. He wrote plainly that Smith was wrongly decided. An originalist is left to wonder, does the free exercise clause require exemptions? We are joined today by 2 scholars who have thought deeply about this important question and written extensively about the debate. Their discussion will be moderated by Mr. Nick Reaves. Nick Reaves joined the Becket Fund for Religious Liberty as counsel in 2018. His practice focuses on First Amendment and appellate litigation. While at Becket, Nick has worked on precedent-setting religious liberty cases nationwide. In 2022, Nick joined Yale Law School as a visiting clinical lecturer in law. Nick's academic writings have been published by the Yale Law Journal Forum, the Notre Dame Law Review, and the Virginia Journal of Social Policy and the Law, among others. Before joining Becket, Nick was a litigation associate at Jones Day in Washington, D.C., and a law clerk on the Third Circuit. Nick graduated from the University of Virginia School of Law in 2015. He served on the managing board of the Virginia Law Review and was elected to the Order of the Coit. Nick graduated magna cum laude with a double major in economics and political science from the University of Notre Dame. Nick?
Thank you, Jake. It's an honor to be here with you all today, and especially to be joined by 2 of the foremost experts on the First Amendment, who both have written and thought extensively about the specific question we're addressing here. I will first introduce our 2 panelists, then I'll give just a 30-second introduction of the question on the table for discussion, and then I'll turn it over to Professor Laycock and Professor Muñoz to give their thoughts. Neither panelist really needs much of an introduction, so I'll keep these short. Professor Laycock is perhaps the nation's leading authority on the law of religious liberty and also on the law of remedies. He has taught and written about these topics for more than 4 decades at the University of Chicago, the University of Texas, the University of Michigan, and now at UVA. Professor Laycock has testified frequently before Congress and has argued many cases in the courts, including the US Supreme Court, where he has served as lead counsel in 6 cases and has also filed influential amicus briefs and many more. He earned his BA from Michigan State University and his JD from the University of Chicago. I unfortunately did not have the privilege of taking a class with Professor Laycock while at UVA, but in my role at Becket, I've had the chance to work with him on numerous amicus briefs and other cases, so it's a real privilege to have him on this panel. Next, I'm happy to introduce Professor Vincent Phillip Muñoz. Professor Muñoz is the Tocqueville Associate Professor of Religion and Public Life in the Department of Political Science at the University of Notre Dame. He is the founding director of Notre Dame's undergraduate minor in constitutional studies and directs Notre Dame's Tocqueville program for inquiry into religion and public life. Professor Muñoz writes and teaches across the fields of constitutional law, American politics, and political philosophy, with a focus on religious liberty in the American founding. I actually took constitutional law from Professor Muñoz as an undergraduate at Notre Dame. It was not an easy class, but I learned a lot. I'd also just briefly mention that Professor Muñoz has a new book out. It's called Religious Liberty in the American Founding. If you enjoy his remarks today or find them thought-provoking, I'd highly recommend you take a look. I think it's both a deep book, but also very accessible. So with that, I'll just give 30 seconds on the question presented for discussion and then turn it over to Professor Laycock. So the religion clauses of the First Amendment are very short. They say that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. While these clauses have raised many questions, one debate that has been ongoing really since the time these words were written is whether the Free Exercise Clause requires individuals with a sincere religious belief that is contrary to a duly enacted law to get a religious exception or an accommodation from that law. And this isn't a hypothetical issue. As Professor Laycock has documented in his scholarship, the list of cases raising this precise issue is very long and diverse. For example, should those with pacifist religious beliefs be exempt from the draft? Or can a city police office require its officers to be clean shaven, forcing Muslim officers to either resign or violate their religious belief that they should maintain a beard? To unpack these arguments on both sides of the issue, I'm excited to turn it over to our panelists, starting with Professor Laycock.
Thank you, Nick. So this is a symposium on originalism. I suppose I should begin by confessing that I am not an originalist. I think history is important. I think many of our constitutional clauses were aimed at solving some problem, and if we identify what that problem is, we can often identify the core of what the clause means. I'm also a serious textualist. I think we have to take the text seriously, and I think it is a mistake to conflate the text, what was actually voted on, with any concept of original understanding or intent or public meaning. And the text is often quite broad and general, and I think we have to take the breadth and generality of the text seriously, but centered on what problem were they trying to solve. Another reason I'm not an originalist is that we actually know far more about the Constitution than the founders did. We have 235 years of experience in administering, interpreting, living under the Constitution, and originalism says we can't learn from that experience. It is all irrelevant. I think that's a serious methodological mistake. There is often no clear original understanding, and that is certainly true on the issue of exemptions. There's not much discussion in the historical record of whether the Free Exercise Clause provides a general right to exemptions for religious objectors subject to necessary exceptions. Their attention was focused elsewhere. The main religious liberty issue, the main church-state issue, was how to fund the church. In 4 of the New England colonies and 5 of the Southern colonies, the established church was tax-supported. That was very unpopular with people who weren't members of that church and with some of the people who were members of that church. But taking that money away from the churches after they relied on it for a century or more was also problematic. So there is much more argument about church funding the Establishment Clause than there was about the Free Exercise Clause. Another reason was the country was religiously homogenous. It was overwhelmingly Protestant. There were a few deep moral disagreements of the sort we have today. It was much more lightly regulated than today, so there were many fewer occasions for the exemption issue to arise. And when it did arise, it could be handled one issue at a time, and it was. And when it arose, overwhelmingly, the colonies and then the early states granted exemptions. So Quakers and swearing oaths, the exemption from oath taking was nearly universal by the early 18th century. Quakers and the other peace churches were exempt from military service. That was nearly universal by the French and Indian War and was universal by the beginning of the Revolution. There were some more idiosyncratic exemptions. You were exempt from removing your hat in court in Maryland. That arose from a famous incident with William Penn. The Jewish population in Rhode Island was exempt from the incest laws so long as they adhered to Jewish law, which are somewhat more permissive than the Christian rules. And everywhere that retained the church tax, dissenters were sooner or later exempt from paying it. Now, to a modern eye, the church tax doesn't look like a neutral and generally applicable law. It looks like a religious law. But to its supporters, it served an important secular purpose like everything else. The more specific point I want to make about this is that even the states that have been most resistant to free exercise and religious liberty, Massachusetts, Connecticut, Virginia. We think of Virginia as a leader in religious liberty, but in fact, the reason Jefferson and Madison had to make their fight was Virginia had been a laggard, and as late as 1773, 74, it was still throwing Baptist ministers in jail for preaching without a license. But each of these states, each of these colonies, soon after they allowed dissenting worship, enacted exemptions, because what they discovered was religious liberty without exemptions doesn't solve any of the problems that religious liberty was intended to solve. Regulating people's religion, trying to suppress their religion causes human suffering. Suffering for the sake of conscience caused religious conflict. 200 years of intermittent religious warfare in England had ended with the living Mary of the founding generation. And simply saying, okay, we're going to tolerate you now, you're no longer illegal, didn't solve any of that. So Massachusetts and Connecticut expelled Quakers for most of their first century. And then they said, well, okay, you can live here, but no dissenting worship, no Quaker meetings. So that didn't solve the problem. Quakers still couldn't live there. So they said, okay, you can have your own worship services, but you still have to serve in the militia, and you can't vote or testify in court unless you swear an oath. And they still couldn't live there. So even Massachusetts exempted Quakers from military service. A ban on religious practice is equivalent to a ban on religion. Now, folks say, well, but all those exemptions were legislatively granted, not judicially. Well, of course they were. Colonial courts had no power of judicial review, had no constitution really to enforce. And then folks say, well, those exemptions were an act of grace. No one thought they were really part of religious liberty. Well, says who? We don't have much discussion of the theory for why they were granted. What we do have is their behavior. And very soon after they granted toleration at all, they began to grant exemptions. We do have the debate on the Second Amendment, where there was a proposal in the drafting of the Bill of Rights in the first Congress to write into the Constitution an exemption from military service, and that was rejected. A vote that was divided 3 ways and was fairly close, but the bottom line is it was rejected. I don't think that tells us anything about the general question, because military service is the hardest issue of all in the exemption debate. National existence had been at stake in the Revolution, and yet every colony exempted conscientious objectors. There are secular advantages to being exempted, so there's strong incentives to false claims. And throughout our history, from Rhode Island in 1673 to the end of the draft in 1973, we've always had a requirement of alternative service or paying a fee or finding a substitute or something to keep that exemption from being entirely free. So resistance to a constitutional guarantee of draft exemption does not imply a constitutional resistance to other exemptions. Bottom line, you can believe in religion, but you have no right to practice it is not a meaningful concept of religious liberty. Not in the founders' time and not in ours. Doesn't avoid social conflict, doesn't involve human suffering. And it makes every contested social policy issue much more difficult, right? If we say to the legislature, you can permit same-sex marriages or you can forbid them, but you can't permit them with religious exemptions, an important approach to compromise is eliminated. That goes to the legislatively granted exemptions. The constitutional exemption, I think, is there for all the reasons, historical reasons I just said, and then finally for the text. If something is a religious practice for an individual, a law that prohibits that is quite literally a law prohibiting the exercise of religion. That's what the Constitution restricts, and that's what Smith attempted to permit. Smith, of course, is unraveling, but that's a different issue. I'll stop there.
Great, thank you very much, Professor Laycock, and now we'll hear from Professor Muñoz.
Yeah, well, thanks so much, Nick, and thanks to Jake and all the members of the Virginia Federalist Society. It's a great pleasure for me to be with you. I'm especially pleased to be here with Professor Laycock. When I was a very, very young scholar, just beginning, I read an article of his, trying to remember the title, I think it was Continuity and Change in Religious Liberty or something like that. And I want to say it's the University of Minnesota Law Review, probably in the early 90s. You should all go back and read that. I still think it's one of the best articles on this subject, very influential in my thinking. And So I'm just thrilled to be here on a panel with Professor Laycock, a scholar I've admired and respected for years. I have a different take on things, but I think I almost agreed with everything Professor Laycock said. So let me try to explain my agreements, but why I come down in favor of Smith, at least on originalist grounds. Whether originalism really works on free exercise is a different question, and I think Professor Laycock pointed to some arguments that not really originalist in character that might lead one to want to overturn Smith. But let me stick to originalism, at least as I understand that's the theme of the day's conference. So let me start with a point of agreement with Professor Laycock. He started with the text, and we should identify the problem that the text is trying to solve. I think that makes perfect sense. What is the mischief or problem that the free exercise clause is trying to solve? And then a clearest way we go about identifying that problem is through the text itself. I'll come back to that in just a minute, but I want to say another point of agreement with Professor Laycock is on, he didn't quite put it this way, I'll put it this way. Originalism doesn't quite work for the free exercise clause. And the usual places we go to do originalist investigations, the drafting record, as Professor Laycock suggested, they really just don't say much. The drafters don't say much. In my book that Nick mentioned, I do a good faith, I'm not a critic of originalism, so I don't have a bone to pick with originalism as a method. I'm not a living constitutionalist. And I do a good faith effort to try to do originalism. And the conclusion of my originalist investigation is that the text is underdetermined. I think there's some evidence that an exemption understanding is not the original understanding, but I won't want to rest my hat on what you could find. There just isn't much evidence. And I want to say one more point on this. It's a very important point, and we forget it. The people who wrote the First Amendment didn't think it was necessary. Remember the story. It's the Anti-Federalists that wanted amendments. And what the Anti-Federalists really wanted, those against ratification of the Constitution, what they really wanted was a second constitutional convention. And they wanted a second constitutional convention because the Anti-Federalists wanted to do to the Constitution what the Constitutional Convention did to the Articles of Confederation. Anti-Federalists wanted real structural changes. They didn't like the Constitution. The men who wrote the First Amendment in the first Congress were all Federalists. And when you read the drafting records, as I'm sure many of you do, you see arguments like, Jimmy, James Madison, do we really have to spend time on this? We won ratification. We have other things to do. We have to set up the government. The Federalists just wanted this issue to go away. And James Madison said, look, we need to draft amendments, not because the Constitution requires amendments to be improved, but because we promised, and more importantly, and more fundamentally, if we, the Federalists, write the amendments, we will kill anti-Federalist opposition to the Constitution. That is, we will solidify our victory. The leading critics will be defeated because we will give them supposedly what they want. And that's why we get the Bill of Rights. But if the people who didn't really think the amendments were necessary are writing them, it's not that surprising that they didn't do an extended debate or discussion on what these amendments actually meant. So there are good historical reasons that explain why at least the free exercise clause, other provisions as well, are underdetermined, right? So we have to go somewhere beyond the Constitution to understand the Constitution. That being said, let's start with the text. Most of the focus, this is true of Justice Alito and Fulton, it's very textual opinion, it's a very interesting opinion. Alito, to summarize a very, very long opinion, says, look, it's free exercise. It's the exercise of religion. And Professor Laycock made this argument just now. And what is the free exercise of religion? Justice Alito doesn't quite say this, but I think most people who want to overturn Smith would say something. Judge McConnell, Professor McConnell says this. The free exercise of religion is religiously motivated behavior. So anything that makes religiously motivated behavior or even burdens religiously motivated behavior cannot be prohibited or even burdened. I'm not sure. In fact, I'm pretty sure free exercise doesn't mean that. And let me give you two reasons why. One is starts with the text, and the second from the founders' natural rights thinking. The textual problem with Sherbert or any exemption granting approach is actually the word Congress. It's very noticeable to me that in Justice Alito's opinion, he does very close textual analysis, but he doesn't actually do textual analysis on the word Congress. Congress shall make no law. The free exercise clause is targeted at Congress and Congress and its lawmaking ability. Let me address it this way. If Sherbert or something like it is correct, the text is effectively read to read, Congress shall make no law, and executive branch officials shall administer and enforce no law that prohibits or even burdens the free exercise of religion. But the text is actually directed at Congress and its lawmaking authority. And I think that's actually an indicator. If you take the text seriously, that's an indication that the constitutional violation, if there is one, occurs when Congress makes a law. And that insight, I think, helps us understand what the free exercise of religion is, at least from an original understanding. Let me go, as I explicate this text, to what is the underlying purpose, because I think the underlying purpose helps explain the text. The underlying purpose of the free exercise clause was to demarcate a jurisdictional limit on Congress's power. That's why it's shall not prohibit. It's not Congress shall make no law that is burdensome. It's shall not prohibit. Congress shall not prohibit the free exercise of religion was meant to convey there are certain powers that Congress does not have. Congress does not have those powers over religion because religion, the founders said, is an inalienable right, or unalienable to use their language. What did they mean by that? What were the founders trying to say when they said Congress shall make no law and that religious liberty is an unalienable right? If you follow the philosophy of the founders were trying to convey that government has no authority over certain elements of our natural liberty. How we pray, whether we pray, what's the proper form of worship. And I think if you look at the founders' philosophy, what you see is the free exercise clause had a much more limited scope and a limited design. It was to demarcate. There are certain things that Congress and no legitimate government can ever do. And that's take authority over our religious exercises as such. Not incidental burdens of religion. This is me constructing the text in light of this philosophy. Not incidental burdens, but Congress directly legislating on religious exercise. This is a legitimate religious exercise. This is a prohibited religious exercise. You are punished or fined because you practice this form of religion. You are prohibited from passing this form of religion. What this would mean in practice is laws that target religion as religion, or target religious exercises as religious exercise. I think that's what was meant to be prohibited. This, in a way, is the separation of church and state, but in a much more precise and specific way. Congress does not have this authority because we, the people, never gave it authority. That excludes the whole realm of what we would call incidental burdens, right? And that would include Quaker military service. Now, these incidental burdens can be alleviated through legislation. There's no doubt, to my mind, that Professor Laycock's historical examples are right. But the First Amendment was not meant to address the problem of incidental burdens of religion. So the First Amendment had a much more limited scope. It was to say there's certain things, direct targeting of religion, religious exercises that the legislative power could not do. That's why the text is categorical, shall not prohibit, right? Contrast that text with the Fifth Amendment, no unreasonable searches and seizures, no takings of property without due process of law. There's not a reasonable limitation of the free exercise that Congress can do. It's shall not prohibit. And it's directed at Congress because the constitutional violation, if it occurs, is when Congress exercises a jurisdiction it does not have. Now, those are all originalist and textualist constructions. Textualism in light of the original problem or mischief that was meant to be served. So I actually agree here with Professor Laycock's procedure. Now, whether an originalist construction of the free exercise clause would work today is certainly a different matter, but I actually think that is the construction, basically affirming Smith, that is most consistent with the founders, the text the founders drafted and their underlying rationale for adopting the free exercise clause in the first place. Okay, back to you, Nick.
Thank you both for your excellent remarks. I would encourage the audience to submit questions via our Q&A function in the Zoom chat. And I'll exercise the moderator's prerogative to ask a few questions of my own first. And I'd like to start with Professor Laycock. I think there were two things I heard from Professor Muñoz that stood out to me. I'd love to get your thoughts on them. One was, it seems like you both have different understandings of what the scope of the free exercise clause protects. And I was wondering if you could talk a bit about that and respond to Professor Muñoz's kind of explanation that it protects, in his words, religious belief and exercise as such. And then second, he mentioned the categorical language of the free exercise clause. It doesn't have this provision that says you can burden it if there's a compelling government interest. And that seems to cut against an exceptions approach because it's a categorical bar on what Congress can do. I was curious to get your reactions to those 2 points.
Yeah, so let me take the second one first. I agree that the absolute wording of the First Amendment matters. It's not unreasonable or what is due, as in the due process clause, or with compensation or without compensation. I think it requires stringent enforcement. We have to give some effect to its absolute nature. I think we've learned from experience it can't literally be absolute. That some things, even religious practices, can just do too much harm in the immediate run. And that goes back to one of the things I said at the beginning about learning from experience how the Constitution actually works. There were, of course, qualifications in most of the state free exercise clauses. And they typically said something like, unless there's a breach of peace or licentiousness, and there were historical reasons why they were so focused on licentiousness, but breach of the peace was the most frequent limitation. And they all came out of the same milieu of thought. So, I think we have to take absolute language seriously, but I don't think it precludes a stringent, compelling interest exception. On the scope of what counts as exercise, even Scalia said in Smith that religious behavior is religious exercise. There is another usage in which religious exercises just means kind of, worship services or rituals. Conceivably, that's what it meant. I don't think that's a very plausible meaning. And again, I would say, look at the problem they were trying to solve. And you don't end religious conflict by simply saying, okay, you can have your worship service, but you can't do anything else that your religion directs, right? You can't, if Jews can't necessarily wear a yarmulke unless we agree to let you, and you can't grow a beard unless we agree to let you, and you have to serve in the military unless we agree to exempt you. You haven't eliminated or reduced religious conflict really much at all on that interpretation. And I don't think that we can dismiss as merely an incidental burden the state regulating those things, right? It's a direct burden. And I don't think it matters a whole lot whether we call it a criminal fine or whether we call it a loss of benefits. Wisconsin versus Yoder on whether Amish children had to go to high school was a criminal prosecution, but the penalty was a $5 fine. And when Joshua Davey couldn't get a scholarship at a state school in Washington, he lost thousands of dollars. And I think, I don't know why that's any less serious than the $5 fine. And as Justice Brennan said for the court in Sherbert v. Berner, they're really equivalent, right? Taking away somebody's benefit has the same effect, same deterrent effect as a fine for practicing your religion. So that's my reaction to how do we read exercise, and on absolute wording, I agree it's significant, but that experience teaches there has to be some exceptions.
Great, thank you, Professor Laycock. So Professor Muñoz, I'll give you a chance to respond to that as well. And I could just throw in one more question while you're thinking about that. It seems like you both generally agree that the text alone doesn't give a complete answer. Like you said, it's kind of underdeveloped, or it doesn't give a complete originalist interpretation. But it seems like the question is, where do you go from there? It seems like Professor Laycock looks more to experience and tradition and what's happened since then. And it seems to me like you jump from there more to a natural rights theory. And I was wondering if you could address why you think that's the right place to go from the text to kind of the founders, what's in the founders' head, what their natural rights understanding was. If you could address that as well.
Sure. Yeah, I'll do all those things. Let me start with your question, and then I'll comment on some of the things Professor Laycock said, which again I largely agree with. What do we do if the text is underdetermined? I mean, just in a way, Professor Laycock and I agree here. You shouldn't just take our word for it. You should go study the primary documents and evidence yourself. But let's just take that as given, that the text is underdetermined. There's not a crystal clear original understanding, at least that what we see in the historical evidence of what the free exercise of religion is. You go to the state constitutions. Professor Laycock mentioned there's this, well, in the state constitutions, there are free exercise or religious liberty protections. And one just clarification, these are often in the declarations of rights, sometimes in the constitutions. And the state declarations of rights were actually not technically part of the state constitutions. They're more like the preamble or the Declaration of Independence or statements of principles, but really no matter. There's additional language, and maybe that additional language will reveal something. Now, if that additional language in the state constitutions, these peace and safety provisos, reveals that free exercise was exemptions, then you have the issue, well, there's not a peace and safety proviso in the First Amendment, so does that cut against exemptions? I mean, all this evidence is, you're going to have to interpret it, or to use the language of constitutional construction, construct it. The evidence just isn't clear what the original meaning was. So where do you go? That's your question, Nick. Where do you go? I think there's good reasons. We go to experience, that, as Professor Laycock said. We think about, well, even if this was the founders' problem, what is the problem today? Managing social conflict, especially based on religion, that might be a good place to go. My argument is that if the first free exercise clause sets forth a principle, and I think it does, I think we're both in agreement, there's a principle of religious liberty. If you want to be originalist, then you try to uncover the founders' principle of religious liberty. And so you have to think about what the founders said about religious liberty and what they say about religious liberty. This is very clear. They say it's an inalienable right. So we've got to figure out what work is the word inalienable doing, right? And if you do that work, you'll see that there are two types of natural rights. There's alienable and inalienable natural rights. Inalienable natural rights pertain to things powers we can't give to government. And that leads to a jurisdictional understanding. And that's all in the philosophy of the founders' social compact theory of natural rights and inalienable natural rights. And my own train of thinking was, following that path, all of a sudden it became clear, oh, that's why the text of the First Amendment is categorical. The founders' text actually matches their philosophy, this natural rights philosophy. And they're saying, oh, it's a jurisdictional limitation. There's some things Congress can't do. Well, what can't it do? And then you have to follow out the founders' philosophy. And when they talk about it, they talk about what I called a direct burden. Let me clarify what I mean by direct and indirect, because Professor Laycock's obviously correct. I mean, let me just use the Smith case, right? To the guy who's ingesting, the religious practitioner who's ingesting peyote, it doesn't matter if the government wasn't targeting religion. I mean, his religious practice was illegal. So from the experience, Professor Laycock's point, from the experience of the believer, the burden. It doesn't matter if it's direct or indirect. I'm using that language of direct or indirect to talk about the state action in question. An indirect burden is when the state's not targeting religion. So in the peyote case, the Smith case, it's Oregon made they criminalized hallucinogenic drugs, peyote being one of them. The law said nothing about religion. It just made a class of drugs illegal. The experience of the practitioner was direct, but the law legislated an indirect burden. So just so we're on the same terms here. My argument about the purpose, the underlying purpose of the Free Exercise Clause is not that the purpose was to end conflict pertaining to religion. The actual purpose, I think, of the Free Exercise Clause was to prohibit direct legislation, direct burdens on religion. It's a much narrower purpose. I think it's fair game to say, well, the founders' purposes don't suit our times, right? I mean, that's a different type of argument. It might be a compelling argument. But if we're going to be originalist, or at least the spirit or original philosophy of the Constitution, their purpose was much narrower. Now, let me say one other point on this. Goes to the first thing that Professor Laycock said when he talked about experience. His argument, correct me if I'm wrong, Professor Laycock, is something like this. So we've had 200 plus years of experience. If I'm going to put words in his mouth, if Professor Muñoz is even right about the original meaning, that doesn't work today. It doesn't protect enough. It doesn't get us where we want to go, which is to end conflict based on religion. No one wants to make the Quaker fight a war, or no one wants to make the Native American church ingestion of peyote illegal. If we're going to have gay marriage, we don't want to criminalize or make difficult the lives of traditional religious believers. So the limited non-exemption approach doesn't work today. And that might be a way of cashing out what it means to learn from experience. And again, I think there's a lot to be said for that. It's just not an originalist argument. So if you're an originalist, I mean, every originalist judge says this. They say that sometimes you'll reach results they don't like. Well, this might be an originalist result that originalists don't like. The founders were trying to solve a different problem, not our problems. And keep in mind that the founders didn't think the Bill of Rights or the judiciary were meant to solve all problems, right? And maybe that's the main point. I mean, yes, a limited jurisdictional First Amendment, like I'm suggesting, might allow all sorts of harms to be done. But I think it's a mistake to think that they thought the First Amendment would solve all problems pertaining to religion. They had a much narrower understanding. Maybe that understanding is not sufficient today. My job is really just to try to point out what that understanding was.
Nick, could I say just a word about that? When I talk about experience, it's not just that I don't think the narrow view works today, which is once again a time that's highly polarized on religious grounds, but it hasn't worked at intervals throughout our history, right? Actually, I mean, the 1780s when we wrote the Constitution were a time of relative religious peace, although there was a big fight going on about how to finance the church. In the 19th century, with the huge Catholic immigration, right, we had decades of intense conflict, including at the extremes, people dead in the streets from mob violence, the militia called out, churches burned to the ground, convents burned. And then we had the Mormon persecution. And neither of those things were new experiences, right? Madison talked about rivers of blood flowing in the old world from the vain attempt to eliminate religious disagreements. Eliminating that kind of conflict is part of what this clause is about. I think it's wildly out of context to try to understand it without that as an essential part of the purpose.
Yeah, let me say one thing on this. But I think the exemptionist approach to constitutionalism is exactly opposite to the way Madison thought social conflict based on religion would actually be best addressed. And here my evidence is Federalist 10. Madison thought the equal application of law, that is not non-exemptions, is the best way to resolve social conflict over religion, right? What is the multiplicity of interests? This is Federalist, not the multiplicity of factions, the multiplicity of interests. And you have to think through, how does the multiplicity of interests lead to more harmony? And the mechanism is when everyone has different interests, you still have to get a majority interest, and you have legislative bargaining. And that process of legislative bargaining leads to the moderate position. And the moderate position is Madison's approximation of what would foster the common good. But that whole framework, his whole premise is that there are no exemptions from the law. The legislative bargaining only happens and only reaches the moderate position if everyone is subject to the same law. So exemptions undermine Madison's constitutional philosophy and constitutional mechanisms. In Federalist 57, he says, the context here is the House of Representatives, and he says, how do you make sure you get just legislation? And he says, the surest way that the House members will be faithful to their constituents is if you make sure that the law applies to them and their friends. That is, the equal application of the law is the surest way to just results. And what Madison wanted to do was only have laws that you could apply to everyone. Now, his constitutional design may be deficient, but his answer wasn't exemptions. So even getting to the same goal that Professor Laycock wants to get, or we might want to get, ending conflict, doesn't necessarily mean exemptions. It could be that a political science of non-exemptions better accomplishes those ends. At least that's what Madison thought. Whether he was right or not, it's a different question, but I'm sure that's what he thought.
Yeah, exempting the influential from secular laws is one thing, but I'm not aware of any occasion in which Madison objected to the religious exemptions that were in place.
The Memorial and Remonstrance itself. I mean, if you read the Memorial and Remonstrance, Article 4. So the law in question was Patrick Henry was proposing a religious tax, and one of his criticisms is that there's an exemption for their tax for Quakers and Mennonites. It was a reasonable exemption because they didn't have clergy. The way Patrick Henry's funding bill, it funded clergy members. So what do you do with denominations that don't have clergy? But Madison criticizes the exemptions in Article 4 as improper. So I actually think there's very good evidence to show that he criticized exemptions.
Yeah, I don't think that's what it shows at all, but we're getting into the weeds now.
I would like to ask another question, since this is a panel on originalism. And then after this question, I have a couple audience questions, but please submit additional questions and we'll get to those as well. This one's for Professor Muñoz. We heard earlier today from Professor Solem about the various strands of originalism. He talked about original public meaning and the constraint principle. Hearing you today talk about how you get from the text to what is in some ways sounds to me like the founders' philosophy. I guess my question is that really a strand of originalism? If we're not constrained by the text, if we're not looking at the original public meaning, and maybe you could talk a bit about original construction and how your approach fits within this kind of big tent that is originalism. If it's not really focused on perhaps how the words themselves were understood at the time, by those who read them.
Well, I think you have to look at all the words, and for reasons I said earlier, I think the construction I offered actually makes sense of the words Congress and shall make no law. So it's the words we don't know what the meaning are is free exercise. But we actually know what Congress is, and we know what shall make no law is. So any construction or interpretation should make sense of all the words. So I think my answer to your question, the first answer is, well, any construction should be make sense and be coherent with the text. I mean, ironically, Alito's opinion in Fulton, which he says is textualist, the result he wants, which I think is Sherbert or something like Sherbert, you can't actually square with the text. I mean, it's a very odd sort of textualism he practices. He criticizes Scalia for not being consistent with the text, but he never shows how his preferred interpretation would be consistent with the text. And I think he doesn't try to do that because he can't, but maybe that's a different question. Whether constitutional construction itself is compatible with originalism, I think is a fair question. And it might not be, it depends how broad, how big your tent actually is. Most originalists would say, look, if you're in the construction zone, you just shouldn't be doing anything if you're a judge. You should just defer to the legislature. I would point out that that itself is a construction. There's no rule in the Constitution that says if the text is unclear, you have to defer to the legislature. Moreover, let's say you do defer to the legislature. Well, Congress has an obligation to construct the text too, to interpret the text. So even if judges don't do it, someone has to construct the text, right? Congress, to know what it can do, has to have some understanding of what the free exercise clause is. So someone's going to have to do construction, even if we don't want judges to do it. I think it's fair game for judges. So if you admit there is underdetermined text, you're going to have to someone's going to have to construct the text. And then the question is, how do you construct it? And I thought Professor Laycock, his text and the underlying problem or mischief makes perfect sense.
All right, we have about a little under 15 minutes left, so I'm going to turn to some of our audience questions. I think this one, maybe I'll start with Professor Laycock, but I'd love to get both of your thoughts. The question is, what do the historical sources tell us about the meaning of the word religion, and how capacious is that concept?
I don't think they tell us much about original understanding. They seem to use religion and conscience interchangeably, although there's debate about that, and there have been attempts to tease out what they meant by conscience that might have been different from religion. And there were multiple drafts in the first Congress, some of which were about religion and some about conscience and some about both. I do think that in our time, religion has to include the negative answers to the great religious questions as well as affirmative answers. So we have to protect non-believers. That's a hard sell to most judges these days. Harder in the exemption context than in other contexts. We do have decisions to protect non-believers in a variety of ways, and they get some protection from the free speech clause and so forth. That's a whole nother and difficult issue. But I think if you had asked the average man on the street in 1788 what religion was, he would have talked about Protestant churches, because that's what 99% of their experience of religion was. But I don't think we get much detail about what they thought the borders of the concept were.
I think everything Professor Laycock said is exactly right. I mean, I think we can safely say that we know that the drafters of the Constitution didn't mean just Protestants, and we know this because they were pretty, if you look at the state constitutions, for example, the language pertaining to religious liberty says all individuals, all men. And elsewhere in the Constitution, when they wanted to limit some civil rights to Protestants, they said Protestants. So if we take their drafting to be precise, they clearly understood the natural right of religious liberty to pertain to all. But what exactly is a religion? They didn't talk much about that. Again, we have a little bit of evidence on when some Anti-Federalists criticized the lack of religious tests for office, and the Anti-Federalists said things like, well, this might mean a papist, a Catholic, or a Mohammedan, a Muslim, might be elected. And here James Madison and other Federalists said, yes, no religious tests for office might mean a Muslim or a Catholic gets elected, or Jew will get elected, if they win the favor of their constituents, of their fellow man, of their citizens. If they get enough votes, they should be elected. And Madison and other leading Federalists were adamant about that. So we know they didn't mean just Christianity, but they didn't give us a sociological definition of what exactly is religion or the boundaries between religion and non-religion. Let me just say one other thing, because it's just really a point of agreement with Professor Laycock, at least in a precise manner. The free exercise of religion also protects the non-exercise of religion, in the sense of clearly, I think we all would agree that the government can't mandate religious exercises. That would be a violation of the free exercise. And so I'm Catholic, and if they mandated Protestant religious services, that would violate my rights. but it would also violate the atheists, right? So I think the free exercise clause, just in a way we'd all agree, by prohibiting government from mandating certain religious exercises, certainly protects non-believers.
Great. So the next question from our audience is it fair to say that the court's acceptance of single secular exemptions to defeat Smith's general applicability test make the test look more like the least restrictive means analysis? In other words, is the court shoehorning strict scrutiny into the Smith test? Professor Laycock, maybe you can speak to that one first.
I don't think I would say it sneaks in strict scrutiny by the back door, although it has an equally destructive effect on what Scalia may have thought he was accomplishing in Smith. Smith is an utterly terrible opinion, whether you like the result or not, because it is profoundly ambiguous. He only had 5 votes. It was pretty clear at least one of them wasn't willing to overrule anything. He never quite says what. He's got a few sentences about what free exercise does protect, but he never says what he means by neutral or generally applicable. And he never draws any kind of a line, and much of it is done. Much of the work of the opinion is done in parentheticals and subordinate clauses. And so in the immediate wake of the opinion, I published an article, and it's in the 1990 Supreme Court Review, if you're curious. It said, I can count at least 7 exceptions to his rule here, one of which is kind of like a most favored nation clause, that if you let some secular group do this, you have to let religious groups do it as well, or you have to have a compelling reason why not. That was dismissed out of hand by every lawyer working for a government and by most academics, but it's what the Supreme Court is now finally doing. They didn't get it from me, or at least not in a direct way. But I did help kind of put it out there in the general debate. It's a strong form of non-discrimination rule, right? Yeah. If some preferred secular interest group gets to do an activity that causes the very same harm that is the government's alleged reason for restricting a religious practice, that's a problem. And non-discrimination is more complicated with respect to religious exemptions than with respect to, say, race, because there's so many possible comparators. There's not just 2 or 3 other races or 1 other sex. There are dozens of potential comparators. And so it becomes a pretty strong protection, but it is a form of non-discrimination rule. I don't think it's, and it triggers strict scrutiny if you show that others are allowed to do this, but I don't think in itself it's a form of strict scrutiny. Let me add one.
Basically,
that the current court has gone much too far with it. They're comparing religion to things that actually don't do as much harm as what's being regulated in some of the COVID cases.
I basically agree with everything Professor Laycock said. Let me, if I can just ask a question for Professor Laycock. Sometimes I think all this stuff should be done under the Equal Protection Clause and not the Free Exercise Clause. Does that make sense? I mean, it does seem like equal protection.
Well, yeah, I mean, there was a lot of talk in the early reaction of Smith. They reduced the Free Exercise Clause to just the Equal Protection Clause. And I was one of the, I said that among other things, and so did lots of other people. That free exercise is a substantive right to practice your religion, whether or not anybody else is allowed to do the same thing. And the sort of non-discrimination view made it like equal protection. And and he's got a footnote where he compares to Washington v. Davis, which is a big equal protection case. So if Smith is all it is, we probably could do most of it under equal protection. I guess it says religion is a suspect category, even if it's reduced to a equal protection mode of analysis.
Yeah, I would just add one other thing here. There's something Professor Laycock said, spurs me to say this, that Scalia's religion jurisprudence, he's much better at saying what the Establishment Clause and what the Free Exercise Clause did not mean than he was in clarifying what they actually prohibited Congress or the states with incorporation from doing. I've been waiting for an enterprising law student to write an article on this. What does the Free Exercise Clause actually prohibit, according to Smith, and what does according to Scalia, and what does the Establishment Clause actually prohibit, according to Scalia? His negative jurisprudence was a little bit clearer than his positive jurisprudence.
He's got one long sentence at the beginning with a bunch of subordinate
Yeah.
clauses, says what the free exercise clause protects against, and everyone had to bet, was he serious about that, or would those things get thrown out the door the next case?
So we got a number of questions kind of about where the rubber hits the road. And so we only have a couple minutes left. I wanted to frame this up for both of you to address. I think it's interesting that at the end of the day, you both seem to agree that, for example, I think Professor Muñoz, you mentioned this in your book, the Little Sisters of the Poor probably shouldn't be forced by the government to provide contraceptives to their employees if it violates their sincere religious beliefs. But you get there in a different way. And I'll let you both maybe address whether you actually do agree with that statement, and if so, kind of how you get to that result. Maybe Professor Muñoz, you can go first.
Yeah, well, I'm racking my brain thinking through my book where I talk about Little Sisters of the Poor. And you may be more familiar with my argument than I am. My immediate reaction is that Little Sisters of the Poor, assuming the law is otherwise valid, I don't think the Little Sisters of the Poor have a free exercise right. Now, what Madison might say, to go back to our earlier conversation, is the Little Sisters of the Poor should have been a little bit more animated in the legislative stage, right? And showing how this will, when this law is applied to us, will burden us. And again, this is Madison's idea. If those arguments were activated, we're less likely to have this law in the first place. But at least my understanding of the original meaning of the free exercise clause is that Little Sisters of the Poor wouldn't get an exemption. Doesn't mean it's a good law. It doesn't mean there couldn't be legislative exemptions. But at least in my understanding, there's no constitutional right, assuming the legislation does not target a religious group or religious practice as such.
And I think that's what I was getting at, if it was an inarticulate question. I thought in some places in your book, you talked about how there were other limitations on what Congress can and can't do that would do a lot of the same work as what people are trying to push into the free exercise clause.
Yeah, and my larger point here is that, really my first point, the free exercise clause, at least in my understanding, had original meaning, original purpose. But religious groups, like other groups, will be protected by other parts of the Constitution. I mean, I think one thing that's happened in jurisprudence is, lots of economic rights, the freedom of association have been very narrowed, and therefore we throw a lot of things into free exercise that might fit other places, at least from an original perspective, fit better in other provisions of the Constitution. And there is a real problem for originalists, and I don't try to solve this problem. Is it coherent to have an original understanding of free exercise or original construction of free exercise if you don't also have an original understanding of freedom of association and the takings clause and the commerce power? It's not clear to me that originalism is coherent unless you do the original Constitution as a whole. And I think this is a problem that originalists haven't really faced. It might be that I'm right on how narrow the free exercise clause is, but the narrow free exercise clause doesn't work unless you reinvigorate the original meaning of all these other clauses. Maybe Professor Laycock would say, well, look, our experience we have to take the whole into account, and therefore, if we want to fulfill the underlying original purposes, we're going to have broader protections under free exercise. I mean, I think that's a very plausible argument.
Mm-hmm.
Let me just say a word about protecting yourself in the legislature. I think it's completely unworkable because there's so many legislatures, right? So the Little Sisters often will have an aroused interest group on the other side, all the feminist groups or all the gay rights groups on related issues. And if they lose this year in Congress, they lost. But if they lose in state legislature, they lost. If they lose in the county commission, they lost. If they lose in city council, they lost. If they lose in an administrative agency, they have lost. And the issue never goes away. They got to win on all those places year after year after year. They'll be full-time lobbyists, and they won't be a religious group anymore.
Mm-hmm.
Yeah, I actually agree with that, but I think that's actually a criticism of Madison, not me.
Fair enough.
Well, it is 3:45. I want to be respectful of everybody's time, so I'll turn it back over to Jake.
Thank you, Nick, and thank you to our panelists for a great discussion on the free exercise clause. Join us in 15 minutes for our final panel of the day on the Second Amendment in the Bruen case. But again, thank you to Nick and thank you to our panelists.